right, what is up, y'all? Sorry about that delay. We were having a little technical difficulty back there with some sound, but we got it all worked out. Welcome to the docket. I'm your host, Bob Mata. My beautiful better half, much better half, unfortunately, is slaving away on a PCRA petition, and she just can't finish it. So I had to sub in another brilliant mind tonight, and that is none other than Shay Hughes. Brilliant criminal defense attorney in Indiana. As an amazing Twitter account that you all should be subbing to or following or subscribing, whatever the hell you do on X. I don't know what it is. Shay, tell them what is your handle over there on Twitter, because everyone should be following you because you always have primo tweets or X's.
Well, I really appreciate the kind words and thank you for having me tonight. But you can follow me on Twitter at public defender _ and then on Instagram at Hoosier Public Defender.
Love it. Yeah, dude. I mean, your stuff's always on point. It really is. And I love having you on because you know your shit, man. So which is super helpful because I don't practice in Indiana. I mean, I've had to get familiar with the law over there, but then you get stuff like this that pops up that doesn't necessarily. I mean, you guys, like every state has a tendency to kind of be a little lax on the rules in certain counties.
Right.
Like we know what the hard and fast rule is, but sometimes we go fast and loose with it, and it doesn't typically matter until it does. And then you have to ask, well, if there's, why are there rules if no one's following them? Because when it comes to a situation like we got, and even though we've only got a couple orders that I want to talk about, one, it's really just one line, but I want to mainly talk about obviously the order that dropped today. There's a lot to talk about. There's a lot to unpack there.
Sure.
So what I'm going to do, I'm going to throw the thing up. I'm going to read through it, and then we're going to start dissecting it. All right.
Sounds good.
Because I was, I mean, were you a little surprised before we start reading it when you read it?
Yes, I was very surprised, very surprised. I saw your tweet and I really couldn't believe it.
Yeah, me either, man. It was a lot. It was a lot. All right. Okay, so we're little, it's big. All right, so let's just start at the top here, man. So this was issued today, 1/22/24. And Shay, you guys refer to this as kind of a minute order, right? Where she's basically drafting the order right into the docket, basically.
There is an order uploaded. I mean, I have downloaded that, but it's in the docket itself for whatever reason. I'm not sure why that is. I'm assuming it might be because some people may not have entire access to my case. I don't know, but
all right. Yeah, let's see what she has to say. So the court, having had defendant's motion for Frank's hearing filed September 18th, 2023, the memorandum in support of the accused motion for Frank's hearing filed September 18th, 2023, the defendant's supplemental motion for Frank's hearing filed October 2nd, 2023, and defendant's additional Frank's notice filed October 3rd, 2023. The state's objection to the defendant's motion to suppress filed June 13th of 2023, and the state's second objection to defendant's motion to suppress filed September 25th, 2023, under advisement, now denies the defendant's motion for a Frank's hearing. The court finds that the affidavit submitted in support of the issuance of the search warrant contained information that a reasonable belief existed that evidence of the murders would be found in the defendant's home and vehicles. The court does not find that the affidavit submitted false statements or that the affiant omitted statements with reckless disregard, nor does the court find that the affiant intended to mislead the judge by failing to present information. As the court has found that the affidavit for issuance of the search warrant was valid, the search itself was reasonable and legal under the Indiana law and the Fourth Amendment case law. Defendant's motion to suppress fruits of the search of 1967 North Whiteman Drive, Delphi, Indiana, filed May 19th, 2023, is also denied based upon all the pleadings, memorandums, and exhibits previously submitted in support of the request for the Franks hearing. Defendant's motion in limine regarding ballistics filed June 13th, 2023 is reviewed and denied without hearing. The court finds the evidence contained in the defendant's exhibits A and B attached to the motion is relevant and admissible. The court further finds the probative value of such evidence is not substantially outweighed by its prejudicial impact, and that the evidence will not confuse or mislead the jury. Defendant's motion to transfer filed January 12th, 2024, which was actually filed by Scremin and Labredo, taken under advisement pending the state's response, if any, and a hearing to be set. The state's motion to amend information filed January 18th, 2024 will be set for a remote hearing. So there you go, man. There it is in all its glory. I mean, what were your first impressions?
I was shocked. I'm really, really surprised that there's no hearing on the motion to suppress. I thought they met the standard to have an evidentiary hearing, which is they needed to show some type of statement of reckless disregard for the truth, which I think they did, and that there was an offer of proof, right? I mean, there's many, many exhibits that are supplemented with that memorandum. So I think you're there. I think this ultimately requires an evidentiary hearing. I don't know. I mean, yeah.
So I obviously felt the same way. You know, I'm going through it, and you know, correct me if I'm wrong, but I mean, in Illinois, the way we do it is essentially we have to kind of give an offer of proof, or typically we have a hearing to decide whether or not there's enough there to go to a full evidentiary hearing. But we almost like I've never had in Illinois a judge rule on the written motion without at least having that preliminary finding stage, whether or not there exists enough to move forward to a full-blown evidentiary hearing. So, I mean, I would not have been surprised had she gone through that hearing and denied it. You know, I mean, because ultimately, you know, my feeling on it was that even if she took out the statements from Liggett that appeared to be not exactly what was said in the statements by the witnesses, that if she removed those, that she would still find that there was enough there for them to have conducted the search. Like, that wouldn't have surprised me. But to just to just move forward and do this, and really, we can't look at anything where it's not through the lens of the fact that we just had a Supreme Court oral argument take place where the justices all to a justice made it clear that what had happened with respect to their removal without a hearing was improper, you know? So I understand it's a different circumstance. I do. I get it that they're different circumstances, but in terms of the visuals on it, it's a bad look. You know, I mean, like, people were surprised that she wasn't removed. I wasn't. I thought she should have been. Don't confuse what I thought was going to happen as to what I, you know, was hoping was going to happen. I was hoping obviously she'd be, you know, because I just can't see a world in which these two attorneys and Gull can exist and get this thing done properly just because of the animus. You know, it's like anytime you challenge a judge like that as a defense attorney, it does not bode well for you anytime you're in front of that judge. And to have it go down in the middle of this thing before we're even at trial, to me, you know, moving forward, if I'm Andy and Brad, I'm like looking at this like, man, you know, this is going to be hell on earth. You know, this is just going to be, everything's going to be pulling teeth with her. And, you know, even from her perspective, I'm like, man, like, is it worth it for her to sit on this shit? I mean, people have already formed an opinion on her, no matter what her background is. I mean, like, everything that I heard about her and read about her going in was that she was highly respected, that she was a competent judge. And this case just hasn't really reflected that. Now that's no reflection on her past years of being a judge. Maybe she's been phenomenal, but here in this case, in my opinion, she's been awful, for a lot of different reasons. And, so I mean, looking at it through that lens that we just had that go down, man, I just have to wonder, like, where her head's at,
Right. Yeah, I'm not sure. I think some in the public may view this as she feels emboldened, right? Look, this is not an affidavit that I would feel terrific just ruling based upon briefing and nothing more. The other thing I have to note, that order, it's pretty short. I think I don't even think it uses the right standard. I mean, she references a reasonable belief, but the standard of review for a search warrant isn't reasonable belief. It's if there's a substantial basis for concluding that there's probable cause. There's no authority cited to. The other takeaway that I have from it is, if Alan's attorneys lied about something, I mean, or they're incorrect, this would be her opportunity to call them out for it. And that's not there.
Right.
And so I mentioned this earlier, as time goes by, I mean, I find Brad Rosie to be very credible. And if there was something there, right, we would hear from it, right? I mean, even the state in their response really, I mean, they referenced that Liggett didn't omit any information, but they didn't expand upon it. So,
Right.
Overall, I'm really troubled, really, really troubled by all this.
Me too, man. And I really am. And, from the perspective of, what you were talking about, can you flesh out what you're talking about with respect to those standards? So you've got the standards which
Right.
it appears she applied. Like, just break it down for lay people,
So,
because
what I could say is when you're a reviewing court and you have a search warrant in front of you that's being challenged for probable cause, you have to determine whether or not the judge that had that search warrant before him had a substantial basis for concluding probable cause existed. That's the standard. Okay. You're not going to find substantial basis referenced in that order. Okay. Now, what I will say, significant deference is given. Okay. And, but deference isn't boundless. Right. And then, the only thing in addition to that is, you're not, for a suppression hearing, you're not necessarily entitled to a hearing itself. With that said, I think it's always best practice anytime there's any type of motion before you, or really when there's an evidentiary related motion, that you do set it for hearing. That's best practice. For an evidentiary hearing, as I mentioned before, all they need to show is that there's some type of, deliberate false statement, or there's been a statement that's been put in there with reckless disregard for the truth. A good example would be if we take, Betsy Blair. I think she was the one that thought that the person was, or she told police that the person was younger, right? And that was an incomplete statement. There's nothing mentioned there about the person appearing younger. And I think there's also something in there about a Ford Comet or something, the vehicle just not matching up with what Richard Allen was driving at that time. So, putting in what they put in the search warrant, nothing more, is reckless, right? It's not a complete statement. And then the other part of that is an offer of proof, that you mentioned before, and I think they've done that. I have little doubt that they didn't do that. I mean, in fact, if they didn't have an offer of proof, she probably references it within her order. But there's many exhibits provided in support of that memorandum, so I have little doubt, that they didn't provide an offer of proof. So all told, it's just extremely perplexing how this did not go to an evidentiary hearing.
I mean, just it really is in light of everything that just went down. Like we can't pretend what just went down didn't happen. And while theoretically you're right, she could feel emboldened. Maybe that's her thing. Maybe she, this is her way of pushing back and just like a big fu to those guys and saying, look, I survived it. This, put a minimum of law on there. I mean, again, this is now the appellate record. This is now what the appellate court, should Alan get convicted, this is what they have to rely on in terms of her reasoning and her rationale as to why she denied not one, not two, but three motions in one fell swoop in 1 minute order with no case law cited, with the wrong legal standards. And I mean, it's flying in the face of everything that the Supreme Court just said, because like my thing was coming into this, I'm like strategically, like I'm sure your mind was spinning as well, like trying to figure out, all right, what's the move? All right. And like what I want to get into you or what I want to get in with you like first is, so right after we get the order, which
Mhm.
came unusually quickly,
It
same
did.
day, few
Yeah.
hours later, we get that. We're like, damn, that was quick. And we know that Brad Rosie had filed a motion, and here we call it a motion for recusal. I think it's probably something similar there. He
Right.
had filed that after the 19th, but before the 31st. So before they entered their pro bono appearances and after Gull considered them to be withdrawn. So he then files, as we all know, and when she came out, she said Andy had withdrawn orally back in chambers. Of course, and you and I talked about this already, without the benefit of Rick Allen being in the room or in the courtroom when she announces it. At neither place was the defendant whose rights we're talking about. Dude
Right.
was absent. And at that point, she says that Brad has said orally that he is going to withdraw, but he wants to put it in writing and then he'll get back to her once he gets it done. Instead of doing that, he then says, all right, you know what? I'm actually not going to put it in writing. And actually, I'm going to tell you that I consider myself, I'm filing a verified statement that I am still Rick Allen's lawyer. And same day, he then files his motion to recuse her. So that's where this thing is pending, because I was over on Criminality's channel today and Teresa was talking about it, and I had been talking about it with Kara via text. And we all know that if that's a valid motion, right? If that's a valid motion,
Mhm.
she is at a juncture where she cannot make these rulings. If that's considered to be a valid motion, like if there's a pending motion for her to be, for recusal of her, that stays, all the proceedings in terms of substantive motions have been filed. So that's where this thing gets weird. You know what I'm saying? It's like
Right.
I never thought that Brad withdrew. Like, I mean, and I think when we had you on last, I think you read out the statute in terms of what's required to withdraw in the state of Indiana from a criminal
Right.
proceeding, and which was written notice, definitely to your client. I think there was a timeline. I think you said it was like 30 days, and much like Illinois, we have the same thing where that's lax. There's plenty of times where I get into it with the client and they're like, like, oh man, I'm done with you. Fuck you. And, I'm like, all right, well, you want me to withdraw? We'll go in, we'll get in front of the judge. But the judge, again, will have my client right next to me. And the judge will say, sir, your attorney has filed an oral motion to withdraw. And he or she will have the defendant on the record saying, yeah, this is where I'm at with this guy. Like, I'm done with them.
Sure.
Or in the event that I filed something, and given short notice to them. Because in Illinois, much like in Indiana, I mean, a defendant can waive their appearance, but they're expected to be at court. In custody, they're typically going to transport them. I mean, I've had occasions where they haven't, but for the most part, my defendants are there, so the difference being is that the defendant, because again, it's really all about the defendant and them getting it's their rights that are being affected. So, I mean, to me, that weird time frame of that he's filed this thing and it's there, but she's not recognizing it as being actually filed because he wasn't Rick Allen's attorney is kind of where this thing hangs in the balance. You know what I'm saying? I mean, even though,
right,
if the Supreme Court comes back and says, all right, you know what, we're going to basically do this nunc pro tunc, which just is Latin for, now meaning then or then meaning now, and they make it to as if they had never been removed, which would then mean that his motion was valid at the time that it was filed. If they
right.
nunc pro tunc it back to the 19th and say, nah, you didn't have the hearing, he was never removed, that motion for recusal is good to go, and you had no way to be able to deny these motions right now down the road, which is a possibility. Like, that was the whole thing with me. Like, how do you do this without waiting for the opinion to come down to find out what the court's rationale is? You know what I mean?
That's true. Yeah. Right.
So I don't know, man. It's a really weird situation. To me, it's a really, really weird situation. One that I really can't wrap my mind around, because it's one of those things where, I mean, the court could come down with that rationale, like, in a lot of different ways.
Right.
I mean, like say, for instance, say they come back and say, you should have had the hearing. That had you had the hearing, we may have found that you were right, and we don't reinstate them. Do you think she could then, I mean, after pulling this, I would not put it past her to turn around and, do a sua sponte motion to DQ these guys again, go through the whole thing again. Because she clearly doesn't give a shit about how this thing is getting administered. I mean, that's the one thing that's clear to me. She does it. She appears to not care. That's it's like, for any hope of this thing, like, kind of moving forward, in a calm ocean, this made clear to all of us out there that are observing this case, that is not happening. This thing is going to be a bumpy ride all the way through. So I don't know, man. I mean, if you're sitting there and you're Brad or Andy, what's your move? What would have been your first move coming out of that hearing and getting that order that day? Like, just speculating as to what you would have done. What would have been your first move?
The order that just came out today, what my first move would be? Or
no, when they got reinstated, like, you're back on the case. Yeah. What's your first move?
Probably file a speedy trial. That would be my first move, to show, publicly we're serious,
Yeah.
That would probably be the first one. And then, I'd probably file a renewed motion for change of judge. It's difficult for me to, I don't know. Let me ask you this. Because you had mentioned, you weren't surprised if, that they're reinstated, but she's still on. I guess it's difficult for me to kind of parse those, because I think they're one of the same. So how do you think that the court's going to rationalize that?
I think that ultimately that they're going to and it's funny that you say that, or you say that, because that was Mark Lehman's kind of like approach. Like he thought it was the same thing too, because when we walked out of there, and I was concerned, and I told Kara, I'm like, man, like not like Gull being removed was not broached in any way, shape, wasn't
No,
mentioned.
no.
It wasn't even
No.
mentioned. And and I had said to Kara, I'm like, man, I mean, they're definitely not removing her. And like she had said what you said, well, we consider them to be essentially the same argument. That it was what's good for the goose is good for the gander. What applies to them applies to her as well. And the way that I kind of looked at it was, because we can't pretend the politics of it doesn't matter, because it just does. I mean, we can't like pretend like that doesn't exist in the world, because the politics do exist in the world. And I think ultimately the way that I felt about it is that they had their hat to hang on their removal based on the fact that she failed to have the hearing.
Right.
Okay. And in terms of her removal, that they didn't have any evidence before them of actual bias, like, which I think would be the only way that they could really remove her. I mean, like she's
Yeah.
clearly not conflicted out. It would have had to have been some kind of showing of bias.
But
And it's one thing for all of us to sit around and say, "Oh, look what the shit she does." Well, that's us. Even as attorneys, we could say, "Yeah, clearly that shows bias," but it's a different standard, I think, if you're going to have a court remove a judge, because it sets a precedent, a dangerous precedent, to where kind of what Gutwine was arguing. If you create this thing, as to the lawyers, but also as to
Mhm.
Gull, if you create a situation where you've now made it possible to get rid of a judge because you don't like the way that she's ruling on things, and you're just making a bias argument, now everybody's gonna be running in on original actions trying to boot their judges. You know what I mean?
Yeah, and I get where you're coming from, with that. My thing, and I'm sure you'll agree with this, is, I think there are, how do I say it? Uh, there are some issues that are so big, right, that I think inherently show a bias, right? Um, so, in this instance, there could be a significant due process violation. And I think there was in this instance, right? No evidentiary hearings held. She's, well, as it relates to bias, I mean, she essentially came to her decision already, right? I mean, October 11th, she sends out an email saying, cease work on the case. Now, if you don't want to infer anything from that, fine. But then she already has a prepared statement. Um, I think, to me, there are some violations that are so significant, that you just can't be placed back on the case, right, to oversee it. Um, and I think that's what this rises to the level. I don't know. Maybe there's something I'm not considering, and there's a good rationale. I just thought ultimately, the court should just say, in this case only, she's being removed, um, because you could see a scenario like today playing out, right? Um, and you want to avoid all that, and you don't want to be part of that. People are going to think, the public's going to think what they're going to think, and people are going to say, well, you essentially condone this behavior, you know, and you just, I don't know. If I was Chief Justice, I wouldn't want to be part of that.
And I agree, man. Obviously, I mean, I think that the way that the Supreme Court was able to skirt the issue of removing her was by way of saying to basically the public at large, look, she didn't conduct the hearing. There was no hearing. Meaning that the removal in and of itself, because of the lack of that hearing, is why we're reinstating them, thereby getting rid of all those issues that you just talked about, the lack of due process, the lack that she, you know what I mean? In their minds, it never took place. So that gets rid of the fact that she gave them no notice, that she like hoodwinked them into coming in there. Oh, yeah, I'm approving your motion for cameras in the courtroom. Oh, yeah, you know, Nick McClelland's got his case ready to go. None of that mattered because it never really went. You know what I mean? So that way they were able to avoid getting to that question, because you're right. Had it gotten to that, had she gone to the hearing, had she said, you know what? You know, I don't care if you're withdrawn or not. I'm going out into that courtroom and we're doing this goddamn thing right now. And good luck, buddy. You know, and they weren't prepared. Hennessy's not prepared. They have no witnesses there. You know, they don't put on a defense. And I think in that situation, then the court would have had the ability to say, okay, you know what? This was such a gross violation of due process, not even of Brad and Andy, because I mean, they're not the defendants. We're talking about Rick Allen. Like everybody has to remember, this is always about Rick Allen, you know, and for his attorneys of choice, which at that point we know that he had unequivocally stated that they were his lawyers of choice. And when the Supreme Court, you know, when the justices were talking about it, you know, and Mark was saying, oh, you know, and he read the letter into the record, you know, but what he didn't read in was the fact that Gull acknowledged on the 31st to Richard Allen himself, as he's sitting in the courtroom, sir, I understand that you want these two men as your lawyers. Unfortunately for you, I'm not going to let it happen. I mean, she acknowledged that he wanted them as well. I mean, it was very well established that's who he wanted. You know, so all I'm saying is I think that the way that the Supreme Court is going to probably end up coming down on this thing is, that's what I'm saying, that like nunc pro tunc thing may work in terms of them basically invalidating what she just did today, which does not stop her from just denying them down the road. You know what I mean? But it'll we have to anticipate we're going to be getting an opinion back from the Supreme Court that's going to be talking heavily about due process and having hearings. And the fact that she did this, which I think, and I might be dead wrong, you know, I think she did it for exactly the reason that you said. That's why I asked you what your move would have been. The speedy and to re-up on my motion to recuse. She wanted to beat them to the punch to make sure that she could get these rulings in before she was shut down, because she has an argument that they were not counsel at that time. You know what I'm saying? So I don't know. So I'm sure there's going to be questions in here. I'm trying to go through. Mandy, if you see good questions for Shay, throw them up here. So here, Shay, I was told by a very smart appellate lawyer friend that the search warrant doesn't meet the particularity requirement, and she cited case law to me backing that up. Any thoughts on that, Shay?
I think there are a number of issues with the search warrant overall. I mean, it's not something that I would have drafted, you know, if I was assisting the state as a prosecutor, assisting the detective. I mentioned this before, and people have kind of gone back and forth with this. I think there's an issue of how law enforcement got to that address, that is in fact Richard Allen's address. You know, there's a vague reference where Richard Allen says something to the effect of like at that home, and then his wife, there's a reference of at the residence or something of that nature, but there's nothing that explains how people, I think it's Whitman Drive or something like that. I could have the wrong street address, but how law enforcement had probable cause to believe that that was his address. You know, it wasn't raised, but you know, again, I think it kind of shows just, I don't know, you know, how kind of sloppy that search warrant was drafted. The one thing that I'm curious to know with it too, I've never made this argument overall. Well, I've made it in some respects, but not challenging probable cause is, I think the fact that if a prosecutor assisted with drafting the search warrant, then I think there's an even, how do I say it? There's an even bigger issue if it lacks probable cause or if things are recklessly omitted. To me, I think that a search warrant where a prosecutor assists, which is often the case in some jurisdictions. I know it's in ours where the prosecutors are pretty heavily involved. I think it needs to meet a higher degree of scrutiny. Now, people may push back and say, well, that's not a good idea because then law enforcement isn't going to go seek out with prosecutors. But that's one thing that I would be interested in knowing, and we don't have an answer to it, is if any prosecutor insisted with drafting that search warrant.
Yeah, and let me ask you, like, dude, you would not believe how often I get into these debates with people, Twitter, about like who's drafting affidavits for either PCAs or search warrants on major cases. And I keep trying to explain to people, I'm like, look, and maybe it's an Illinois thing, I don't know, but on major cases where it's the attorneys that understand the burdens that have to be met, where law enforcement doesn't necessarily understand those burdens, it's always prosecutors. Now, that doesn't mean that they're not sitting with the cop in the room with them saying, all right, what do you got? And then the attorney's drafting it. But man, like, how do y'all know who's drafting what? Because obviously the affiant is always the cop, like, signing it. It's much like we all know that Brad or Andy wrote that letter for Rick Allen because he doesn't have access to a computer because the dude's in his cell 23 hours a day. He's not going to the library typing up, yeah, I want Brad and Andy as my, you know what I'm saying? So in the same sense that was done, like, how do y'all find out who drafted warrants or PC or affidavits?
Well, we generally have to depose the officer, and the other thing that I can say, related to that, and I had this come up one time on a case of mine. I didn't raise it, I just referenced it, but you run into these issues where law enforcement is having this conversation with the judge or the magistrate about what to put in there. And that's a problem, right? Because they're supposed to be, neutral and detached. And at some point you're playing advocate when you're telling law enforcement, well, I need to know this, I need to know that. In my case, from a couple years ago, or about a year ago, the magistrate told law enforcement, I need to know how you guys found that address. How did you guys get there? And, I didn't raise the neutral and detached because it was a single question, but I put in a footnote and said, at some point, you're no longer becoming neutral and detached. I can only imagine, and again, I don't know, but I'm assuming that those conversations go on a lot more often than we'd like to think. So that's one thing.
And I think in this case, it would have been Diener. You know what I mean? Like,
Right.
I think because we know for the safekeeping thing, like that came up during the hearing that, that they filed the thing and either the court itself or the court's clerk helped them tweak some things and sent it back for signature. I'm like, which is what you're alluding to, and that was when Diener was still on. And then, as we know, like, Diener and his whole bloodlust comment then recuses himself from the case, which is
Right.
always like sat very oddly with me. Like, I've never, because you're talking about a county that's got 2 judges, I think, total, so it's like,
Yeah, two
he knew it
judges.
was
Yeah.
going to get shipped out. So what else? I jumped in there. Did you have a second point on that?
Oh, no, no, no. I have nothing further.
Okay. All right. So, like, we're at this juncture, we've got the Franks denied. We got the ballistics, and I want to touch upon the ballistics. And it was strange that Brad and Andy termed it as a motion to eliminate. We're typically filing those like on the eve of trial, like, I mean, those are the things that we're litigating last moment in terms of things that are going to get in, things that aren't going to get in, things that are allowed to be said, things that aren't allowed to be said. So they filed that. I mean, do you guys file what they termed a motion in limine, like early, like all the time? Is that standard fare in Indiana?
Yeah. Unfortunately, kind of the practice is they usually get filed pretty late. Just a handful of days before the trial. I generally try to do it ahead of time before the pretrial conference. But for the most part, I don't know. It's something that I would have dealt with differently. I probably wouldn't have had a motion to eliminate. I would probably just title it motion to exclude evidence, and reference kind of the case law and why I think it should be invalid. With that, I will say I've said that this is probably going to come into evidence. This is in that defense probably should have beefed up their motion. There's a Maryland Supreme Court case that's, I think, pretty phenomenal, a 4-3 decision that ultimately kept out this tool mark evidence and really questioned the science behind it. With that said, though, it's not the greatest ruling either, because I think they did ultimately allow it with some conditions, and there's that. But some of that I do put on. I put on Alan's counsel. I think they should have had a more thorough motion prepared for that issue. But again, it's something that I would not feel comfortable not having a hearing on. I think it's something that should be argued in court on a case like this.
I agree completely. And I think we talked about it last time, because I think we were kind of running through some of the stuff that was pending. And like, I just wanted to be clear, like Indiana, y'all don't really like subscribe either to Daubert or Fry, right? You're kind of like an anomaly state. Like that's the way I understood it, right? Like,
We
because
go off
that
our
was
rules, our evidence rule, and I think we're Daubert can have some influence, but it's not. It's only persuasive authority, and we have our own jurisprudence that we go off of.
right. And from what I was understanding, and based on what you had said, which I think was the basis for you saying, look, I think the thing's going to get in. It's going to go to weight, the weight of the evidence in terms of, but like in Illinois, in a Daubert hearing, for those that don't understand what it is, and we use Daubert here in Illinois, which is basically where you have experts come in and testify that a certain piece of scientific evidence that you're trying to get introduced into evidence is viable, that it's got scientific, it's got validity in terms of the scientific community. And, you have an expert that's going to come in to testify as such. And ultimately the judge is going to rule whether or not they agree. And it sounds like, there, because it basically, the concept being you're trying to keep junk science out, like you just can't have somebody like the state, come up with, oh, we came up with this kind of expert that no one's ever heard of before, and get things introduced as if it's established science, science. So like, but here, like the magic words that you want to hear your experts say is, within a reasonable degree of scientific certainty, I can say this. Do your experts, can they say that there? And I realize that that's typically lost on jurors, because those terms of art aren't necessarily important to jurors, but
Yeah, I'd have to think. We did. So it doesn't really come up. I haven't really had any of the degree of scientific certainty come up. I mean, I think they're allowed to say that. Things have changed with like DNA and so forth, the lab, of how they reference things. But yeah, it's been a minute since I've looked at that. So
yeah, well, I mean, you
guess
don't
it
need
is.
to.
Go ahead.
Because you guys don't really use it. You know what I'm saying? It's like, that's what I mean. For
Right.
us, it's like everything that goes, like we had a trial where they were trying to introduce a brand new DNA testing type algorithm that came up with much more powerful, like their final numbers were what you want to see in terms of 1 in 7 billion, that it's
Right.
it's basically, it can only be that guy. And the guy who had developed the algorithm and the testing wouldn't turn it over, because we were like, well, we have to have a Fry hearing, and I have to have our expert review it to see if it's valid science. Like he can't just come in here and with some kind of black box thing and be like, oh yeah, I ran it through my wonder machine and it popped out that this is the guy.
Right.
Well, you have to be able to allow somebody else to vet your work and make sure that it's actually valid. And the guy wouldn't turn it over because he's saying it's proprietary. I can't give you what my algorithm is, because then the value of my company is lost, because everyone will know it and everyone can use it.
Mhm.
So ultimately the judge kept it out because we couldn't even conduct a Daubert on it. Like a Daubert, and just, I know I keep saying that, y'all. Daubert is a Supreme Court case that came down years ago that was trying to help. There's been a couple. Fry and Daubert are two cases that the court used to be as instructive as to how to kind of manage scientific evidence and how it's dealt with in terms of evidence being admissible or inadmissible. And some states still use Fry. I mean, we don't use Fry, we use Daubert, but it's like every jurisdiction is different. So they ended up keeping it out, but he put a stipulation on us. Like he put a stipulation on our guy and said, if your guy testifies that the DNA does not, like the DNA that they found, the 1 in 12 as opposed to the 1 in 7 billion, because that was the range. It was like drastic. It went from
Right.
like, it could have been one of the jurors' DNA to it could only be him. Like, that's it. He's the guy. And he said, if our guy were to come on and testify that that was not our guy's DNA, that there wasn't, like, it was a mixed sample. They couldn't, there was no way they wouldn't be able to determine it. Based on the loci, I could tell that, like it wasn't his. It's not a match. It's not a match to his. That if he had done that, that they were going to allow this other dude without the hearing come on and give his findings as to the DNA profile. So it was like, we called it the nuclear option, because that one little bit, like, again, jurors don't care about the science side of it. Their eyes like glaze over and they're
Right.
sleeping with their eyes open. You know what I'm saying? So I don't know, man. Because again, like the bullet or the unspent casing getting in is damaging in the sense that the people of the state of Indiana want justice for the girls.
Right.
And the guy sitting in that chair is literally on the hot seat. You know what I'm saying? And when they're going to have a guy come up there, even though he says it's his subjective opinion that casing matches up with the gun that they found at Allen's house, and even though the defense will put their own expert on and they'll be able to say everything that guy just said is bullshit, it's not going to matter. All the jurors are going to remember is that they had a guy who said that bullet matched that gun. And it's
Right.
really, really hard to overcome that, man. It's like, no matter what the science says. So I don't know, man. All right. So, I mean, where do you see this thing going, man? Like I'm assuming this, well, let me ask you this. Do you think that the Supreme Court, who now is going to be aware that this happened, I mean, do you think that this will be touched upon in the opinion kind of as an addendum? I mean,
I'd be surprised if it's gonna be touched on in the opinion, but I do think we're gonna get an opinion is gonna be published sooner rather than later now. I find it interesting. I think somebody tweeted at me asking, you know, uh, are they going to consider the latest safekeeping motion? And is that going to play to anything? And I tweeted out, no, just thinking, well, it's not part of the record. But sure enough, the Chief Justice made reference to it, right?
yep. Yep.
Um, so someone's looking at the docket. Whether or not it
Yeah, I mean,
changes.
they're definitely looking at the docket. You
Yeah.
know what I mean? They're definitely looking at it. I would like if they're in the middle of drafting this opinion, I would be shocked. And like I said, I wouldn't be shocked if it's not in the opinion, but I wouldn't be shocked if it didn't affect some of the things that they wrote in the opinion. They may not reference it directly,
Right.
but it's such a weird move on her part. You know what I mean? It's just like because Karen and I were both like talking about it after, and we're like, I'm like, oh well, and I think Kara said it. She's like, wouldn't it be interesting if like one of the justices just gave a call over to Judge Gull and said, yeah, you know what, we didn't remove you, as basically as a tip of the hat to you and in deference to you as a judge, but we think you probably should recuse yourself from the thing. And I started to think after she dropped this order that this could be her like parting salvo, that she's gonna deny all their motions and then she's gonna turn around and recuse herself. I mean, I could see a world in which she would do that. I really do. Because essentially all the defense attorneys could do at that point is a motion to reconsider. If she was in fact to recuse herself, say, okay, here, I'm going to deny all your motions, and now say la vie, I'm outie. Take
Mhm.
care. I mean, but they're doing like is that what you guys do if you have a judge turn down, they deny a motion? Could you guys I'm assuming you could do a motion to reconsider, right?
Yeah, motion to reconsider. I've never run into, procedurally an issue like that, but I would imagine it would just be a motion to reconsider.
Yeah. But it would be interesting if it wasn't her, because typically in a motion to reconsider, you're asking the judge, the very judge who ruled on it initially, to say, "Hey, I think you screwed up that that ruling.
Yeah.
I'm going to cite a little extra case law. Here you go. Like, here's your chance to make it right." And it rarely ever happens. I've rarely had a judge ever reconsider their initial opinion and say, "Yeah, you're right. I really screwed that one up, man.
Mhm.
Here you go. Motion granted." But it would
Right.
be interesting if in fact she did recuse herself. If they did do a motion to reconsider and it went in front of a different judge. You know what I mean? And that
Mhm.
judge may have a different opinion on things. Well, let me ask you this, man. Like, so in a world where she does recuse herself, because again, I just don't see what the benefit of her staying on this thing is, because as you can see in the chat, as you saw on Twitter, every time she makes rulings like this, it's going to be that response. Even from people that are on the pro, like Alan guilt train, they were like, man, that was a crazy move.
Right.
It's like, I just, so if she does recuse herself, where are they pulling a judge from? There's nobody left like, where do they get us? But where do they pull a judge from?
I don't know. If again, if I was on the Indiana Supreme Court and if I was Chief Justice, I would be looking for the best available senior judge out there, someone that has nothing else going on, that could just treat this like a full time job and then some, and be there at a moment's notice. Conduct the hearings in Carroll County and get this on the road. Because that's the other thing too. You have an Allen County judge uh, with an Allen County jury, um, and then for a brief moment in time, with Allen County Defense Counsel.
Seems a lot like an Allen County case.
Right.
Yeah.
So
All
that's
right.
another thing
Speaking of
too.
which, yeah.
I just don't. I don't. The whole change of venue thing. I just. I don't get. I think it makes more sense to ultimately have it entirely venued out of Carroll County. I can only imagine what that courthouse is going to be like on a day-to-day basis of rolling in a jury in and out. So
Nightmare.
yeah.
And it's small. It's small. Like
It's
when I went up to
small.
the court, it
They're
is.
they're probably gonna have to commute from here in Lafayette, and that's not great either because the jury is only about 25 minutes away. Um, yeah, I can only imagine.
Yeah, like I don't like so when my dad handled Gacy, that was like one of the first that was the first case in Illinois where they imported the jury from Rockford. All right, because they were like, there's no way we could get a Cook County jury. And they imported them all in from Rockford, which is about an hour drive,
Mhm,
northwest. And and they put them all up in hotels. They were sequestered in the city. And I mean, it's like some people call it a change of veneer. I still call it. I mean, conceptually, it's a change of venue. It really, like, theoretically, because you're
mhm,
importing the jury, even though the locale is still the same. Because ultimately, it's where that jury pool that comes from, in my mind, is what. But yeah, you're right. Like the logistics of that teeny little courthouse and like dealing with the crush and
yeah,
and just the size of the courtroom itself, like thinking selfishly, like what time am I going to have to get up in the morning to go get in line to sit in on that trial, man? It's like,
right.
am I going to have to put a tent out there and start an encampment where I'm like, I've become a resident of the front lawn of the courthouse of Carroll County during the
Right.
trial? I don't know, man, because it's like when you went to like Allen County, and I don't know that that's her courtroom that we were in, but it was just a massive, beautiful courtroom. It was gorgeous, man. It was one of the more beautiful courtrooms I had seen, and I've been to a lot of them. Yeah, I don't know how that's going to play out, man. But I agree with you. Like, I hadn't even really thought of that aspect of it. Like, just kind of the real crush. It's like we get a baby crush now, like of humanity and press. But when this thing starts in earnest, man, it's going to be a thing. And I
Mhm.
think it'll be less so if there's no cameras in there, which I want to get to you like after I ask you this next question. So right now, Shay, Rick Allen, per the docket, has 4 lawyers. Now, you're a PD, and so these guys got reappointed, and I have not seen Scremin or Libredo withdraw. I mean, how does that work? I mean, theoretically, unless Rick Allen, I mean, even if Rick Allen says, I don't want these guys, Gull could she say, "That's your appointed counsel, you don't get to choose, I'm keeping him on"? I mean, is that a possibility?
I don't think it's a possibility given the order, right? I mean, order says the reinstated is court appointing counsel. Again, I'm perplexed why there isn't a withdrawal. I mean, if I was involved and I was either one of them, I would have just filed my withdrawal reference the court's order stating that prior counsel has been reinstated. Therefore, that ends my appointment. Right.
Right, but, like, it would be one thing if they had reinstated them as pro bono private counsel. You know what I'm saying? They reinstated them as public defenders. I think because of that small distinction, she actually might if Libredo and Scremin have the balls, can be like, "Well, the Supreme Court didn't say that we were done." You know what I mean? Because like, when I come in as crazy as it sounds, I could see a world in which these 2 guys are like, "You know what? I read the order from the Supreme Court, and they didn't say jack shit about us withdrawing. They said that they're back on as
Mhm.
public defenders just like we are. So, as far as I'm concerned, Rick Allen now has 4 lawyers, and, like, because, like, in the real world, when somebody comes and hires us and they have a PD that's been repping them for, the balance of their case, as soon as we come in, the public defender's like, "My God, thank you very much, sir. I'm out. You just took one off my docket. I appreciate that. And there's no issue." In this
Mhm.
case, where it's a highly sought after case for any kind of criminal defense attorney that's in private practice, and three of the 4 are, Libredo is actually the public defender in Allen County, but Scremmons has his own practice, just like Andy and Brad do. I could see a world where, like, we're these guys are still on there. I just started thinking about it. I'm like, well, the Supreme Court didn't tell them to F off. Like, go, you're done.
Mhm.
These guys are back. Like, by way of them coming back, you guys, like, everything that happened, like, unless they do that, like, nunc pro tunc thing, where, like, everything that happened, we're going back to the 19th of October, and that's where this thing is starting. Before anything happened, before you came out of your chambers, that's where we're putting this case back in time, which means
Right.
that those guys aren't appointed and that neither of them ever will, like, withdrew, at least in terms of the record. You know what I'm saying? Which I could see
Mhm.
them doing. It's an interesting concept, though. Boy, that would just God, could you imagine that, though? Oh, man. Like, God, the pissing match that would be, it would just be
Mhm.
insane. I mean, like, I could see, like, I wish the court would have been like, yeah, we're putting these guys back on, we're reappointing them, and we're gonna relieve Scremin and Labredo of their appointment. You know what I mean? But they didn't say it. So I don't know.
Right.
Maybe I'm just nuts. Um, all right. So I had another thing that I wanted to ask you. I'm trying to go through here. Um, let's see. Sleuthy says because she's probably going to try to boot them again and doesn't want to have to reappoint. She already got her friends on. I mean, that's what I'm saying. But like that's not her thing. Like what I'm at, Shay is a PD. Like if Alan comes in and says, I don't want these two guys as my lawyer. I mean, Gull has the ability to say, sir, they're appointed counsel. You don't get to, this isn't lawyer shopping time. And he says, well, I've already got two guys. These are my two guys. And she'll say, well, sir, those two are appointed attorneys and they're going to be on the case, but so
Mhm.
are these two gentlemen. I mean, am I crazy or could that actually happen? Could she actually pull some shit like that?
Uh, it could. I mean, unfortunately, that order probably invites more questions than it does answers at this point. So
Yeah. I mean, the fact that they haven't filed a motion withdrawal is weird to me, dude. I
it is
mean,
weird. Yeah.
I think it's weird, which got me to thinking about it. All right, so I know a bunch of people have asked this. Do so aside from a motion to reconsider, which they would have to file in order to even contemplate, do you think there's any ability for them to file on the basis of these denied motions an interlocutory appeal?
I think they have a good case for an interlocutory appeal. Yes, more so on the suppression than the motion in limine. Just because I don't think they've made a very good record on the motion in limine. It's something that I really wouldn't, at this point, um, really, from the defense bar perspective, want them to appeal. But I do think that they have decent grounds for an interlock on the suppression. The one thing that I failed to mention earlier is on pretty much every time that the appellate courts have found that there was not probable cause for whatever reason, it's generally because there's been omitted information. And they've stressed to law enforcement that a judge needs to have essentially a complete record. And when you omit information, it's going to be frowned upon. And, that appears what's happened here.
I agree. I agree. And, like, I don't know how it factored in, because I thought it was interesting and I haven't spoken to you since, Scremin and Labredo filed their safekeeping motion. But like to me, the most interesting thing was the fact that they basically they adopted their their argument as to both. They said that they felt that Rosie and Baldwin's initial safekeeping motion had merit, and even more shockingly, they felt that the memo and the Franks hearing motion had merit. I mean, they came out and flat out and said it. And I
Yeah.
don't know. I'm trying to figure out how shit affected her. You know what I mean? Like in terms of, I don't know. So here, let's assume that Andy and Brad are getting ready to file that speedy demand. All right. And explain to everybody so that people have an understanding what the hell that 70-day rule is. Like, so like,
Sure.
what is that rule?
Well, there's a trial rule in Indiana that's separate and apart from, your rights to a speedy trial under the Constitution. That says if you file for a demand for a speedy trial, that you have to be tried within 70 days of the filing of that motion. There can be an extension, I think, for an additional 90 days if there are issues in obtaining discovery and the state's been diligent in doing so. But generally, you have to be tried within 70 days. So, yeah, there's not much to add other than that. But the biggest thing that I want people to understand, it's separate and apart from your constitutional right to a speedy trial.
Yeah, because typically here in Illinois, if you're in custody and you make a speedy demand, trial's got to be within 180 days. It's shorter if
Right.
you're in custody, obviously, than if you're out. And so with the 70-day, are there any kind of issues that may stay the proceedings or toll it a little bit? Like, say, like if it's on the defendant's dime, meaning, like, to me, the one benefit of her doing this, if you're the defense, which could backfire on her, is she has now cleared what I think would have told the time, because these were all defendants' motions, in terms if they want to file the speedy, like the time that it takes to litigate these motions will not be told and not count again. You know what I'm saying? Do they have that kind of tolling provision in there?
You'd still have to fit that within 70 days. I mean, but you are right. I mean, practically on something like that, how do I say it? It's not going to end well from a defense perspective, right? I mean, you've seen it all the time or heard of defense attorneys moving to suppress during a trial, right?
Yeah.
And that's not going to end well, generally speaking, for defense counsel. And you should get out ahead of it. I think there's a criminal rule that basically says something to that effect. So, yeah, you'd still have to address all those matters within the 70 days. With that said, that's what kind of makes this all perplexing, that she issued this order without them having filed anything, because it makes the court look even worse at this point, right?
Right.
It'd be one thing to file it, and you have to push all these things within 70 days, and and then the court denies you at that point. But it's much different when there's just no speedy motion pending.
Right. Exactly. Like, because I'm always trying to figure out what her MO is, man. Like, what,
I wouldn't even bother at this point. There's no,
I know,
I mean,
dude. It's like, seriously though, there's no rhyme or reason to it.
there's none. There's none.
What did you think about McClelland and the additional counts? Like, what's your take on that?
Yeah, I don't really have too much of a thought about it. That's probably how it should have been charged with to begin. And I just didn't understand why there was only that felony murder and nothing more to it. The one thing I can add that I don't get, and again, that it's probably not a huge evidentiary issue, but if you're going to continually reference kidnapping, why not do the lesser included of criminal confinement? That I don't. I don't get, because confinement, I think, is pretty easy. Just as you confine somebody, so substantial interference with one's liberty. which, I think the audio recording is inherent of such, right? And I think the murder itself is inherent of such, right? I mean, those girls intended on going back home, and they did not, right? So I think inherent with any type of murder is that they were confined.
Yeah.
So I just don't know why that's not referenced in its kidnapping. But other than that, I don't make too much of it.
Yeah, I mean, and the one thing that we know is that there was no additional facts or evidence that was presented in terms of the upgrades or the additional charges. I mean, like nothing
Mhm.
changed factually. Which goes
Right.
to your point that this is how they should have been filed initially. If you have the same stuff, evidentiary wise, why didn't you file this from the get? You know what I mean? Because it's like in the beginning, I kind of was like, all right, felony murder. And what is your typically when you see a felony murder charge come down the pike, like what's your first thought? Like
Well,
the
I don't
defense
have too
attorney.
much of a thought because I can't think of a time where I had a felony murder case. So there's that. Look, the one thing I can say is, I don't know if this is because he has somebody new, right, assisting him from what was it, Grant County or something from like Marion, Indiana. I thought wasn't there somebody, and
Oh,
that person
for with
ended.
McClelland?
Yes,
Yeah. Yeah, he had, I forget what his name is because 'cause it's been so long since I've seen him, but yeah, he had I think on the 19th or the 31st, the guy entered his appearance.
and
Guess
and maybe
from what I
that's
hear, he's a seasoned guy.
so. Look, just giving you some the landscape of some perspective of the area and so forth. McClellan, this is his first time being a prosecutor. I'm not aware of him previously being a prosecutor. I think he was defense counsel pretty much his entire legal career. A lot of that was public defender work. Um, I think he was mostly concentrated in Carroll County and a lot of the adjoining counties. He was here in Tippecanoe County for just a bit. Um, but then I don't know what happened with his status and so forth. He wasn't here long, and I can't really speak to why that is. Um, but that's that. There became an opening for Carroll County for the prosecutor. I forget how many years ago. It was Rob Ives, who was a pretty experienced attorney. His chief deputy was Jerry Bean, who was a longtime prosecutor, was actually the elected prosecutor here in Tippecanoe County. They caucused for it between him and Jerry. When I first heard of it, I thought, okay, they're going to select the chief deputy, that being Jerry Bean. Jerry Bean was not selected. Nicholas McClellan was selected. I don't know what that's for. I think Jerry Bean was, he's older, and I think he did have some health issues, but is a very experienced trial attorney. For Nick, this is his first time being a prosecutor. Now, I'm not insinuating anything one way or the other. What I can tell you is there's a learning curve with this. It took me a couple of years of being a prosecutor to really have my feet on the ground and really understand, how to try cases from the prosecution perspective. Um, and he had to select Jerry Beam was his chief deputy, I think, for a year or two, and Jerry Bean ultimately retired, and then he had to select a chief deputy, and it's Shane Evans. I think Shane Evans was recently admitted to the bar. Nice guy. But I think there's going to be some issues here and there with things like charging where, you just kind of fail to see certain things here and there. That happens. It's not an easy job. It's not a job that I envy, right? To to make filing decisions on significant cases. And, he had two major investigations, right? There was this case and there was also the Flora 4. Not easy. And on top of that, having to run an office, and keep everything going, right? Not easy. So I don't envy him in that respect at all, but there's going to be issues here and there.
Yeah, no doubt. And I mean, that's what I was trying to explain to people in terms of like, I think he may have one other prosecutor in there, maybe, and very limited
Yeah.
staff.
I think recently hired a part-time, and maybe that person's full-time. I don't know. It's my understanding that prosecutor and I think his chief deputy are kind of, keeping things afloat while he and this other special prosecutor, kind of work the case, so to speak. But, they got a lot on their plate. And that was one thing that kind of, I'm digressing here. I was somewhat surprised by the fact that they did not agree to a change of venue, because part of that statute actually allows them to receive some additional help. So I don't know.
Yeah, and it's like you said, man. Getting this case dumped on your desk, and from what I understand, he's never tried a murder as a prosecutor. I mean, man, that's a scary proposition, which I think played into part of the defense strategy, because you got a couple of guys at 20 plus years practicing. Each of them have tried big cases, murder cases, and it's not lost upon them exactly the things that you were just pointing out in terms of preparedness, in terms of experience, in terms of readiness to be able to proceed at this trial, man. And
Mhm.
so strategically, it's a smart move from the defense.
Right.
I mean, you're trying to catch him with his pants down a little bit, putting a huge amount of pressure on him to get this thing prepared for trial.
Yeah.
I mean, you and I both know, man, just like in an office that small, with the number of subpoenas they have to prepare, trying to get witnesses lined up, trying to prep those
Oh
witnesses,
yeah.
like
Yeah.
all the stuff you got to do to lead into trial, and having basically no time to do it.
Right. Well, I'm sure this investigation was not easy at all for him. I mean, you're talking about FBI, state police, Carroll County Sheriff. Um, that's not easy. What I found kind of frustrating and somewhat when I was a prosecutor is, each of these agencies kind of play in their own sandbox, and they don't really like to take orders from anybody. And I've always found that kind of troubling, because the reality is the chief law office in a given county is, the DA, the prosecutor, um, and the elected is essentially the chief legal officer, right? And they have the greatest power because they have the ability, they got discretion to file or not, something that, an ordinary police department doesn't have. And I can only imagine, the issues he's run into having to deal with all those agencies. And I think you kind of saw some of it within the memorandum where, other law enforcement agencies may have their own theory and are asking you, why aren't you pursuing leads to suspects in their jurisdiction as well? One thing I do want to correct myself, because I'm looking up and I'm conflating the death penalty statute with the felony murder. Confinement is not part of that. So it does make sense to a certain degree with the kidnapping. With that said, these in total 6 charges probably should have originally been charged.
All right, which leads me right into that next question. In light of the 2 new charges for intentional murder, could McClelland elect to have this be a death penalty case?
Uh, he could, but I just don't see that happening. I mean, what's really changed from here till now? The expense would be a huge expense to Carroll County. I don't know what their budget is or so forth, but it would be a significant portion. And what would you really get out of it at the end of the day? The reality is, if someone's convicted for the murder of Abby and Libby, those sentences are going to run consecutive to each other. I mean, it's going to be a life sentence in and of itself. How do I say this? You're not going to have the same degree of scrutiny, thereafter that you would with a death penalty case, anyways. And with this kind of record, and with everything that's been going on, I wouldn't add any more fuel to the fire at this point.
Brother, you ain't never lied. And it's like I don't think that people understand when we talk about how expensive death penalty cases are.
Yeah.
I don't think they understand what that means, like they don't understand that the appellate process is on the county's dime and it goes on forever, 14, 15, 16 years. And, because Carol was saying the same thing to me. She's of the same mindset that you are, that you guys have it on the books. It's rarely used in Indiana. You guys typically aren't putting people to death out there. I mean, here in Illinois, first we had the moratorium, and then we got rid of it. I mean, it's always been my position, like putting the morality side of it to the side. There's just no harsher punishment than putting somebody in a cage for their entire life, man. Like, to me, if I were like a horrific criminal and did horrific things to people and was sentenced, and I had the choice of being put to death or spending the balance of my life, which could be 30, 40, 50 years in a cage. I don't give a shit if I get to watch TV. Like anything that I take for granted is now like life as it is over. And do we adapt? Of course. I'd rather be put to death. I'd rather do that than live in a cage I mean, maybe that's just me. To me, that's an incredibly brutal, and you're letting them off the hook with the death penalty. That's just the way I look at it. You want them to suffer, then you stick them in a cage forever. With no chance of getting out, because that changes your mindset. It's like old Red told Andy Dufresne, man, hope is a dangerous thing, when you're in here. So it's like, for me, I don't know. Maybe that's just me. All right, let's Shay, we probably got some questions here. So Sleuthy, why was she going to have a Franks hearing for her lawyer friends, but these two lawyers get the denial right away with no hearing? So what Sleuthy is referring to is this particular order that she had thrown up when her boys were first introduced. So she had said, if defendant's new counsel inform the court that they intend to pursue the Franks motion, the court will schedule a hearing.
Yeah, no, good point. I mean, again, the optics are awful. If it's good for them,
good optics.
Why isn't it good for Rosie and Baldwin who filed it?
Yeah, I mean, clearly she didn't think that she didn't think that her Allen County boys were gonna adopt that motion. You know what I mean? I think that was probably her.
I don't get. I mean, the minute you find out that there is omitted information in that warrant, you need to file something, right? And you need to move forward with it. So that I don't get. And to me, I'm left to believe that there was omitted information because the state has had a number of months to file something, and then they have one response that references and says, oh, they're kind of fabricating everything and blowing things out of proportion, but doesn't cite, and point out or quote anything to make us think otherwise.
Yeah, and I mean, you make a great point, man. I mean, if they found deficiencies or omissions or flat out lies when they're going through the discovery, it's incumbent upon, it's their duty to file,
Yeah,
because again, if he gets convicted, if it gets appealed, which it would most assuredly, and if it's an appellate defender, whoever takes it on, and they find it, and these guys didn't do it, it just creates issues. I mean, they're doing what they're supposed to be doing. They're not making things up out of whole cloth.
right.
And I mean, the thing that I just don't get is, like, to me, Gull just gives 0 Fs about the record on this case, man. It's like, it's been that way from the get, and it doesn't appear to me that anything else has changed. I mean, what to me bothers me about this order more than anything else, more than the denials, is that she didn't put the effort in to say, you know what, I'm going to give you a more fleshed out opinion as to my reasoning, citing some case law. I mean, it would be one thing if she put this out just to let counsel know I've denied it. Look for my opinion to be coming a couple weeks down the road. Like the same thing that the court did. She absolutely could have done that. I don't see any language on here with respect to this. I hazard to guess that this is all we'll ever see. And this is now the appellate record.
Yeah, I
I
think
mean,
so.
yeah. I saw this was interesting. Since Gull was an elected official, can the Indiana legislature remove her from this case or from the bench if the public were to request they investigate and have a hearing? Seriously curious, Miss T.
Uh, I don't really have a good answer for that because I'm not entirely familiar with the impeachment process under the Indiana Constitution. Um, it's there, um, but I can't recall what the standard is, and I highly doubt the legislature will step in, even if that's the case. What I can say, folks need to look up Curtis Hill, the former attorney general, and everything that transpired there. We basically had, we had an attorney general that had his license suspended, and then the question is, could he be removed from office at that point, right? Because you need to have an active law license,
Right.
and the governor's office punted it back to the Indiana Supreme Court asking for some guidance. The Indiana Supreme Court said we're not doing that, and the legislature, I think, had no motivation whatsoever to initiate any type of impeachment or removal.
So he
So
stayed in with that, like, without a license?
he was suspended
Was
30
he
days, and
suspended?
then it was
Oh,
business as usual. So,
wow.
to me, that whole thing is probably worth a law review article in and of itself. But
Sounds
yeah,
like you guys have, like, issues with attorney generals like we've had with governors here in Illinois.
yeah,
We've had
it's been troubling. It's somewhat puzzling. All I can add is, if anyone thinks about running for attorney general, just treat the office like a law firm. It's not a political office, and the state's your client, and that's that.
Yep. Yep. All right. So Monkey Do says, let's say this all stays as is. At trial, does the defense get to revisit all these issues, specific discrepancies from reasonable suspicion to probable cause to legitimacy of arrest?
Yeah, still have to make the record, and essentially continue to object, citing whatever evidentiary objection they have or the suppression and so forth. Because that's a big thing, is the Court of Appeals how do I say it? Can be pretty unforgiving if you fail to object, and cite your reason why. So, uh, I wouldn't expect anything major. I don't think there's going to be kind of a full blown evidentiary hearing on the Franks issue and all that during trial. I think you'll just see them objecting for the record, and the court's going to just proceed with trial and note, well, I previously ruled against you.
Yep, I agree. All right. Gilletta 1. If this goes to trial and RA is found not guilty, can they charge someone else with these murders?
Yeah, they could, but I mean, credibility would be very diminished as a prosecutor, right? So
That's what's so scary about this. It's like the thing about cases like this where the families have been told by law enforcement in McClellan, we got the right guy, and then the families put all their faith into that, and I always sit here wondering, and I always do, like when I'm handling my own cases, but like when they drop that memo and the families are hearing about that, they're not oblivious to what's going on. They're not oblivious to
right,
the issues of these other guys, whether they believe the Odin thing is a bunch of bullshit or not. When they hear about a dude like Elvis Fields, I don't give a shit what his IQ is, saying the kind of things that he said to the cops. And if I'm sitting there at trial and they pull out some photograph and put it into evidence of Abby sitting there with what looks like a couple of sticks that are supposed to look like antlers, I'm sitting there thinking to myself, what is going on? You know what I mean? It's just like, it's got to be unsettling to the families to know that
sure,
3 other cops who, for all intents and purposes, seem to be legitimate, good cops. We're talking about Ferenczi, Click, and Murphy, that continued to investigate that aspect long after the unified command decided, we're good. It can't give you a warm and fuzzy feeling as a family of a victim in terms
sure,
of feeling secure. And if you watch carefully, you've got Holman, you've got Carter, you've got Liggett, and you've got McClelland always rallying around the families to, say, hey, don't worry about, we got this. You know what I mean? It's like, it's got a really weird vibe that I'm not used to seeing. Typically law enforcement, the complaint that I hear many times from victims' families is that the state's not keeping them apprised of what the hell's going on with the case. Why aren't you telling us what's happening? And
right,
the state says, well, we have to keep it that way because unfortunately we can't afford to have things leak out. We can't, you know what I
yeah,
mean? So they have to keep
yeah,
them at arm's length. Whereas here, it's a very different story. And I think that it's part and parcel of them trying to bolster the basically the trust that the families have in this case against this guy. It's like,
right,
I don't know if they watch my YouTube lives, and I don't know if they watch other ones. Some people are far more effusive than I am about the case against Allen. I mean, I've basically limited it to, I think it's a very weak PCA. I think that they need a hell of a lot more than that to get a conviction beyond a reasonable doubt at trial. That's just my opinion based on not having seen any of the evidence, based on solely on what I saw in the probable cause affidavit, and additionally to what I read in the memo with respect to what the defense is saying that they have and they don't have. You know what I mean?
mhm,
That's all I can do. That's all I can base my opinion on. So as far as the family goes, man, it's got to be super, super disconcerting to them, and it's like you said, if they go to trial on this thing and they lose it, I mean, what do they do? Do they turn around and then say, okay, well, we whiffed on that one, but now we're going to arrest, these other individuals that were named because clearly they're the guys. You know,
Right.
you're right. There's no credibility to that. You know,
Yeah.
it's a scary proposition, man.
Right.
All right. So, jewels of all trades, off subject a little, but every day I wonder if they know the actual death scene, because if they weren't killed where they were found, ain't no way. Like, you know, I've heard people talk about that the girls were transported there, you know, that wasn't the actual scene. I don't know if that's true or not.
Yeah. I don't
Um,
know.
I don't know either, you know, but you know, I mean, I've heard various theories, which to me are just theories at this point, you
Mhm.
know, but I mean, obviously the questions will be vetted at trial. You know, if you've got a
Right.
crime scene where there appears to be no blood, where you would expect massive amounts of blood to be found, it would indicate that the body's removed, you know? I
Right.
mean, and those are all things that'll be vetted at trial. Um, let's see, signs times. He's being held due to a bullet or eyewitness. I'm not sure I understand the question. Do you understand that question?
I
He's
think
being
basically what are they going off of?
oh, the PCA
A
strength.
lot of
Yeah.
a lot of it is to me is the bullet, that unspent round. Um,
Yeah. And presence, his mere
I
presence, mere
it was mere
presence.
presence on the scene. Yeah, putting
Yeah.
himself there. Um, those are the two big things, but you're probably not filing this, right? If the lab analyst can't come to a conclusion on that round. So
Yeah. Yeah. So Yellow Jacket asked, we addressed this. This was that question about, um, you know, why she's telling Scrummins and Libredo they can have a hearing, but when these guys get reappointed, no deal.
right.
Can you elaborate on Kathy Allen testifying for the prosecution? Are you coming to give me a kiss tonight? I've I've heard people say that, and I have not. I have zero indication that that's true. Have you heard
Yeah,
anything about
I
that?
can't add anything. I can't add anything further. I have no idea.
Yeah, I have some idea, and I've never heard of her being a witness for the state. It goes along with the thing that there was some dude out there talking about some theory that it was Rick Allen's son-in-law. That Rick Allen had told, yeah, dude. I mean, it was like, you know, it's the typical Delphi shit that Rick Allen had told his son-in-law that he did it, and that it was Rick Allen's daughter who turned him in. Where you can kiss. Are you going to bed? Come on, pop in real quick. I love you. Give me a hug. Say hi to everybody. All right, good night. I'll see you in the morning.
Dad,
What? I'm on live.
are you taking me to school or Mom?
Yeah, I'll get you up. Wake me up. So I love you. Sweet dreams. So yeah, like yeah, I don't know. Like the answer to that question. So, but that's part and parcel of that. So that it was the daughter, Rick's daughter, is the one who went to the prosecution, letting him know that Rick had confessed to her husband, his son-in-law.
Hmm.
So that's part and parcel of that. So I have no idea, Professor Pug. I guess we'll find out. Time will tell, my friend. Joshua Hurst, her MO is being one of the prosecutors. I mean, she certainly seems biased. I don't think it's it's not her county. She's not working with McClelland. I don't think that it's anything that
No.
sinister. I just think that, you know, I mean, she's definitely a pro prosecution judge. There's very little doubt about that. Oh, thank you, aspiring. All right. So before I let you jump off, and dude, thank you so much for your
No
time.
problem.
I know you've got a real gig, brother. I know you got to get up, work, do all that stuff. I always value your opinion. You're
I
a
appreciate
smart
it.
one. You're a gentleman and a scholar, so I always appreciate you jumping on, man. I want to get your predictions, just a couple, and I'm not holding them to you. However, if you're right, you could say, yeah, I was on Mata's thing, and I'm just for the record, I want to let you know I predicted it. Come trial, do you think Gull is sitting on this trial? Do you think she's on the bench?
Yes.
Okay. Come trial, do you think that Rick Allen is going to have 4 attorneys defending him?
I'll say no.
Okay. Come trial, do you think that they're going to have cameras in the courtroom?
No.
Man, me too, and it sucks. This case. I mean, I don't know what your opinion is, but man, this case needs to be televised. It's like it's
there's no choice but to. There's no choice but to. I mean, that's the way I look at it. Now you're not holding hearings on major evidentiary issues. You've invited the cameras into the courtroom, but that's just my opinion.
I agree, man. I agree, and just everything that's going on with it. And another argument is to your point. How do they handle the influx of humans trying to get into that courthouse where you have a circus atmosphere, which will only be made worse if they're not televising the damn trial. If you're televising it, I think that that's going to allow a lot of people to stay at home and watch it on their couch, as opposed to trying to get into that courtroom. I don't know, maybe not, maybe. It just seems
chaotic. I mean, people are going to be planted up there for weeks, and it's
dude. Tell me, like, I mean, I plan on being there for that trial. It's like a nightmare. I mean, if they were televising it, I'd be like, fine, dude. Like, I'd have you and Kara on, and like you, Alice, and I, whenever you could spare time during the day, man. I'd be like, all right, come on, jump on. Let's watch this trial together and talk shit. You know what I mean? But it's like, I don't know. So, all right, dude, you're an amazing human being.
No
I really appreciate you more than you know. And again, give out your Twitter, give out whatever you need to put out there to promote yourself, dude, because your Twitter's fire, and you need to be promoting that. So promote it. And I know my mods put it in there too. So, but
yeah, no, Twitter is public defender _ and Instagram is Hoosier Public Defender.
Awesome. And I'm thrilled that I was able to remember to hit go live at the right time, that we didn't spend 45 minutes having a lovely chat together that no one else could hear. So, all right, brother, thank you so much, man. I'll be hitting you up again in the near future, obviously. Frankly, I'd like to have you on when I have Kara on, and I think we were talking about doing it when the opinion drops. So I'll hit you up when that happens, which I anticipate will probably be the next couple of weeks, man.
Yeah. Well, thank you for having me.
Always, brother. You're a gentleman and a scholar. Thanks, man.
Thank you. You take care.
All right, you too. All right, y'all. So let me go through. I'm going to spend a little time. I got the starred questions. I want to take a little bit of time and see if I can see anything. Mods, did you all see anything that I've been trying to look through? See if there's anything in here that I should have asked or was a solid question, or did you guys throw those all up in starred? Let me try to get, I mean, you guys are always so active in the comments, which I love, by the way. I love that you guys are so active in here. You guys are an incredible community. You really are. I can't even begin to tell you how much I adore you. And I'm sorry Allie wasn't here. I know almost everybody's team Allie. I hear it all the time. You guys are giving me a complex, but I don't blame you. I mean, I'm team Allie too. So, but she'll be back. I promise. She's really just struggling to get this thing done, and a post-conviction relief act petition is a serious endeavor, and she's I don't even, like, 180 pages into it, and it's like the whole record. I mean, she's trying to save a guy's life. So, I mean, as much as I wanted her on, I couldn't even ask her tonight. I grabbed her last week because she still had some time, but now it's gotten beyond that. Let me see here. Oh, and I want to give you guys an update. I know I've said it a couple times, and I know Allie brought it up. Our daily morning show is coming. We are waiting to get the set in place. We're super excited about it. We think it's going to be great. It's going to be every single morning. It's going to be short form. It's not going to be this long live stuff. We're still going to do lives, though. We're still going to do lives, but we just want to have something where we're giving our version of the news, everything that happened yesterday, and everything that you could look forward to in the courts on the coming day. We'll have guests occasionally. We're going to have some fun things planned. And again, that's called the morning drop. We anticipate it'll be anywhere from 20 to 30 minutes every morning. And we hope that you'll enjoy it. And we hope that you guys watch, and we hope that you spread the word. If you guys like our content here, please like, subscribe, join as a member. I'm anticipating having our first members only live next week. This week, what I have planned, as far as the Gacy thing goes, Bill Dorsch is actually coming to the States. So I don't know if we're going to be going this week. I hope to get with him live and in person and do a live there. But I'll be having a live with Susan Hendricks. She's got a new YouTube channel that she just started. And if you know anything about Susan, she's been deeply, deeply embedded in this case. She's got her, she's got her theories, and she's been very close with the family. I'm very anxious to talk to her about everything that I was kind of talking about at the end of this live with respect to, is the family feeling secure about that they have the right guy at this juncture? I don't know if she'll have the answers. I don't know if she does have the answers, if she'll give them, but Susan's always a great one to talk to. And I know that we don't agree on everything, but like anything else, I can always have passionate discussions with people who are on the absolutely opposite side of me. And I'm sure Susan and I will be able to have like a wonderful conversation. So I'll let you all know that will be Friday. I'm waiting to hear back from, and it's going to be Dan, her partner, and Susan that are doing their new YouTube channel, which when we get there, I want y'all to be subscribing to that. As far as there's a couple of these things I just have to shout out. The $5 holla from Yellow Jacket. Thank you so much. Adore you. Joshua, $2 holla. Appreciate you. Aspiring, $2 holla. So appreciate you. Mosquito, welcome to the family. Appreciate that. Gail, gifting somebody a membership that's unbelievable. Thank you so much for doing that. Jiu-Jitsu, new member, welcome. Thank you very much. Deja, love you, long time. Member for 1 month. Woo-hoo is right. Nav the EO. I feel like Steve here. Nav, I would say the EO. Nav the EO. I believe I'm pronouncing that right because I really want to pronounce it right, because 50 memberships times 2, 100 memberships from Nav the EO. Wow. Blown away by that generosity, man. That is next level. Awesome. Thank you so much. And I'm sure that there were a ton of people in that chat that just got memberships who are equally, if not more, thankful. So thank you so much, because a gift like that helps build a community, and it goes a long way towards, making this thing just gigantic, to where we've got just so many people. I just it's between Jay and Joe Jackalone and the boys of Publicly Buzz. We're really trying to create a community that, cares about victim advocacy, but that cares about justice. And, obviously we're always trying to Allison and I, we come from the defense attorney perspective. We're always trying to educate people on the justice system. And and what we need in terms of it being able to operate properly so that the justice is being done properly for the victims and the victims' families and for the defendants and for everybody involved. So, I mean, and we love this community. We really do. You guys are just so unbelievable and so giving. Gambies, you're always money. Thank you so much. Many questions. That was for 5 with Gambies, always coming through. So generous. Many questions with a $2 hollow. Appreciate it. All right. My mods aren't putting anything up. If I missed you guys, it's not because you weren't, like, a bunch of those were not, the questions were not paying members. I know Allison could be kind of like, real strict about like wanting members only to ask questions. I'm far more lenient with that. Like I want everybody to have a voice. I know some people don't have the finances for it. So, when she's not on, especially, I'm always going to be sneaking questions. Plus I always guilt her into letting me do it. So, cause everybody should have a voice, money or not. Like it would make me a pretty, I don't know what I'd call it. I wouldn't necessarily call it ironic, but it would make me maybe a bit of a hypocrite if I wasn't giving a voice to the voiceless or a voice to those that may not have as much money as others. So I'll always do that, just so you guys know. All right, y'all. That'll do it. Just short of 2 hours. I hope you all enjoyed Shay. I hope I gave him enough time to speak. Like with Shay, I like to throw questions at him. So obviously I was going to have to speak to him some. So, and I'm always going to be me. And if y'all don't like that, then I'm probably not your channel, because I'm always going to talk some. And I know you guys do give me a little bit of grief about that, but to be honest with you, I love that grief. So, all right, y'all, thank you so much for hanging for all this time. I appreciate you beyond words. I really do, because without y'all, I'd just be an old man talking about old cases. Talk at you next time.